There was a motion for reconsideration filed by the state yesterday afternoon. Could the defense file whatever response they want to file before Monday at 8?
Good morning, Your Honor.
Morning.
I could do that, or we can just argue it now. I think the state's cases and facts are not lined up with the reality of what happened in our case, and I don't believe that. I think it's specious. So I don't think, if you want, I can respond in writing, but I don't believe that the state's motion in any way should affect our time in this case, and we should move forward. And that's my position. I put it in writing, but.
All right. Well, what I'd like is if there are any post new evidence code cases with similar facts to ours. So I'd rather have something in writing if y'all don't mind.
I will, but there's a ton of
All right.
cases.
Well, you don't have to give me every one. Just.
So the state is wrong.
Okay. I don't want to argue it right now. I want a written response. All right. Appreciate it.
Your Honor.
Yeah, I'm about to have fun with this one. So basically, Monday, we're going to see Brian Steele go up and basically keep Dennis from testifying even further. I have an idea of what he's going to say, not the exact case law, because that's going to take way too long, and Seti Nash is not an attorney. I ain't took the LSATs. I ain't took the bar. So please understand, when I say hood attorney, that's 100% YouTube stuff. If you do ask me certain legal things, stuff like that, I will tell you 100%. This is what I would do. This is all of this stuff and everything like that if I were you, but I am not giving anybody legal advice. All of that crap, that is on you 100%. Though I do know some law. I just play dumb. Anyways, so some of y'all was in the comments and was like, why does Brian still have to say anything? Well, remember when Glanville used to say, no, I'm not giving y'all a mistrial, or it's permitted, and the state would have to cite law in order for Glanville to keep his ruling? That's essentially what this is. So some of y'all was basically like, man, the judge should just say, I said he's not coming in, and leave it at that. No, there has to be case law cited as to her ruling to stand in. You see what I'm saying? So let's just get into what the hell was written by the state. State of Georgia versus Jeffrey Williams, Judge Whitaker. State's motion to reconsider oral order striking witness testimony and related exhibits comes now. The state of Georgia respectfully moves this honorable court to reconsider its October 17, 2024 oral order striking the October 17, 2024 testimony of witness retired investigator T. Dennis and related exhibits, and precluding his future testimony as a sanction for an inadvertent non-responsive answer during his testimony. In support thereof, the state shows the following. 1. Background. During Investigator Dennis's testimony, Investigator Dennis referred to actions Defendant Diamante Kendrick performed immediately after his release from custody. Defendant Kendrick moved for a mistrial, which this court appropriately denied. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17, 2024 testimony, precluded him from testifying in future, and struck from evidence exhibits which Investigator Dennis had authenticated on October 17, 2024. 2. The scope of the state's claim. It is inappropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not have not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17, 2024 testimony, precluding the witness from testifying in the future and excluding exhibits which have been admitted through that witness on October 17, 2024 was improper. As an exclusion of evidence which the law does not permit, the state thus respectfully moves the court to reverse those portions of the court's oral order. 3. Analysis. Evidence exclusion is an extreme sanction and one not favored in law. State versus Smith. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly construed as the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation. Burns v. State. OCGA 24-4-402, Rule 402 provides in relevant part that all relevant evidence shall be admissible, except as limited by constitutional requirements or as otherwise provided by law or by other rules as prescribed pursuant to constitutional or statutory authority applicable in the court in which the other matter is pending. Emphasis added. That is, Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17, 2024 testimony, of his future testimony, or the related exhibits, where purported ground for evidentiary exclusion does not come within the exceptions enumerated in Rule 402. It finds no home in any of the specific and detailed exclusionary rules included in the new code is unsustainable. State versus Orr, 503 Georgia, 729. We ain't doing all that. The universe of specific exclusionary rules is limited by statute. First, Georgia's Rule 402 explains that otherwise relevant evidence may be excluded based on the rules grounded in constitutional or statutory authority, OCGA 24-4-402. The evidence code's specific and detailed exclusionary rules are the obvious example, Orr 305 Georgia. We ain't doing all that. Let me go through. OCGA 24-1-2E grandfathers in old common law exclusionary rules, those rules which predate Georgia's current evidence code in the rare instances, if there are any, which such rules haven't been modified by statute. See Chrysler Group versus Walden. That's the list. Under our evidence code, these are the only possible sources of specific exclusionary rules. Let me go down, explaining that the exceptions in Federal Rule 402 are an exclusive list of the sources of authority for exclusion of evidence in federal court. State versus Alamanza. If a rule is the new evidence code is materially identical to a federal rule of evidence, we look to federal law case Stocker versus Rogers, 361, Georgia Appellate 267. Here we go. This is consistent with federal interpretations. Footnotes omitted cases in which appellate courts have rejected even well-established rules of exclusion, which were not reduced to statutory form since the adoption of Georgia's new evidence code in Rule 402 includes State versus Alamanza, super blanket exclusion of offender identification made during medical examinations in child. Whoa, can't say that word, was abolished by new evidence code Chrysler Group LLC versus Walden, super common law rule, excluding party wealth evidence was no longer applicable, Glenn versus State. So they're just basically going through a whole bunch of stuff. Corresponding federal rule evidence 402, which has prospective effect in that it precludes trial judges from further creation of new exclusionary rules of general applicability. While OCGA 24-6-611A, Rule 611, permits a court with control over the mode and order of witness examination, Rule 611 does not authorize an order excluding evidence and thus would not justify the order at issue here. Rule 611A mirrors Federal Rule of Evidence 611 as that rule read in 2011, Smith versus State. Thus, Georgia courts look to federal authority for its interpretation. The state submits that federal courts of appeal are very clear. Rule 611 does not authorize the wholesale exclusion of evidence. Unlike the vast majority of the other evidence rules, 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of which is otherwise admissible evidence. 28 Charles Allen Wright and Victor James Gold, Federal Practice and Procedure, 6162 at 388, 1993, emphasis added, footnote omitted. Although decisions that a court makes under Rule 611 may inadvertently affect whether proof is admitted, the rule does not provide an independent ground for excluding otherwise admissible evidence. United States versus Colum, where a trial court orders such an exclusion, the Fifth Circuit held that the court erred as a matter of law and therefore abuses discretion in relying on Rule 611A to preclude the government from calling the witnesses necessary to present admissible evidence. Further, the matter at hand does not involve evidence which was illegally seized under the federal or state constitutions. See U.S. Constitution Amendment 4, and does not involve a violation of other rules which have statutory provision for exclusion, such as the reciprocal discovery rules, see OCGA 17-16-6, as there is no constitutional right or statutory provision which authorizes the exclusion of Investigator Dennis's October 17, 2024, or future testimony generally, or the exhibits related to it. The order excluding such evidence was an error and should be reversed. Conclusion. For these reasons, the state respectfully moves the court to reverse those portions of the court's oral order in which it struck the entirety of Investigator Dennis's October 17, 2024 testimony, precluded Investigator Dennis from testifying in future, and excluded exhibits which had been admitted through Investigator Dennis on October 17, 2024. Respectfully submitted the 17th day of October 24th, Kevin Armstrong, Deputy District Attorney. How many damn district attorneys y'all got? Man, let me rip this to shreds real quick. You know what's funny? None of those laws cited your damn investigator prejudicing a jury. basically painting that illustration already, saying that he's already a convicted felon. So you're already gonna miss on that. That's why Brian still said exactly what he said. You ain't even cited no law that says if my freaking person gets up here and basically say they're already guilty and I'm a cop and that's gonna prejudice the jury, that yeah, that's gonna work. So Brian's still gonna knock that one out the park. It was all stupid. It was all kind of dumb. So I'm just like, what the hell? What are you talking about? Then on top of that, bro, he can't come back. They don't even understand something. The judge is sparing so many people in this case. And I have something to keep up with y'all as far as Moontoon go. The judge, the freaking judge, literally is telling you he don't need to come back. Why he don't need to come back? Because he is messing up. He is terrible. All of this crap. He's going to mess it up for you. She technically was supposed to kick his ass off and mistrial it. The only reason y'all didn't get a mistrial is because literally out her mouth she said, well, he already was a convicted felon, because basically what they're saying is you're painting him as a bad guy already and y'all had to prove he's a bad guy, not for something that he previously did. Why the hell would you want Dennis on the case anyways? This proves the arrogance. I'm telling y'all right now, this arrogance that the state is running with, bro, it's going to come back and bite them square in the feet. You're going to see them having to do the happy dance because y'all stepping in shit and y'all don't even realize it. Like, I get it. You got something to prove. Y'all done got these taxpayers to spend millions of dollars on this case. But at certain times, other people know better for you than you know for yourself. This is a judge who has been in your position, a judge who has won many cases and now is looking over many of cases. So the state is so damn arrogant. Why would you want Dennis on the stand now? Just get somebody else to introduce the evidence, just like y'all had Aretha Franklin up there. Just do it that way. But you know what? They want to bring Dennis back. Judge said, keep your ass out of my court. Don't come back. Hit the road, Jack, and don't you come back no more, no more, no more, no more. That's what the hell she said, and they mad about that. Why? Because Dennis is likable, somewhat believable, and imposing. Y'all heard Weinstein. I ain't heard sonorous in a minute. Basically, a voice that has tone, that commands. You know, something like Sadie Nash. You know, when I speak, I'll be sonorous as hell. But either way that go, I wouldn't even want him back. I would have been pissed off. You damn near just cost us the case. Why do you want him back? This is like, it's Sunday. It's football. This is like y'all basically bringing back a running back who always fumble the ball. He might get a home run. Go Yankees, bro. World Series, here we come. But he might get a touchdown or burst for 30 every once in a while. He might. But you know what? He Tiki Barber out here. He might fumble the damn ball. Do all good, all great, and fumble the damn ball. And that's what he did. I don't understand why the hell y'all want him in there. Figure out a way to get his exhibits in there. Somebody say the exact same shit. It's all right to see a new face. But it's so damn dumb and so damn arrogant. And they dumb because of their arrogance, because they really think they had this one in the bag. And I can't wait for Duke to march his goddamn big head ass up there and sit up there and literally look these people in the face with my hero Ashley Merchant and say, y'all gave me the worst deal. And now this is about to destroy y'all fucking case. Because before, y'all had unbelievable witnesses. Lion ass Woody, Lil D, that's just trying to get up out of shit. DK ass, who literally was ready to wear wires and look like a robot. Slug, aka Tick, aka I don't know where the hell he went. These assholes, these 4 idiots that went before. Them. Y'all going for them. Now the jury about to see somebody who signed to the label, who literally can explain why the hell it's not a gang. And y'all gonna look pretty damn dumb. And y'all keep on trying to force this immunity. If I'm anybody else, I'm going to literally say, if I'm Brian Still or somebody, because I think Brian Still more than likely going to be the one to cross him. But either way it go, I think Brian Still has to. Because at the end of the day, I don't think Keith can weed it in the right way, the intricacies with Young Thug. But either way it go, you just get stupid stuff like that. And I want everybody who's watching this right now, pay attention to what I'm about to say, because I'm going to make y'all feel a little bit more bad for Mutum. I talked to his family, and the burning question in the back of my mind was, why the hell would he sign that plea deal? And we brought it up before. He was saying yes to stuff before she had even freaking finished the damn question. Listen, imagine, if you will, if you with somebody at a house party and you ready to go and they talking to you and all that stuff, you're not paying attention. You're like, yeah, damn, that's crazy. Yeah, damn, that's crazy. Yeah, damn, that's crazy. That's essentially what he did. I didn't notice, but I found out Mutu Mama was dying at the time. The call that he got, well, when he called home, that's what made him sign that terrible ass deal. Now, I know we supposed to be, you know, whatever and all this shit, but at certain times we can do what others can and show a little compassion. So I did talk to Ashley Merchant. Shout out to the visionaries. Y'all got on her, and she definitely, we reached out to her. We're going to see what we can do, if we can even do anything. If not, then hell, we can at least do something over here. So the family 100% trust me. But y'all hold on to y'all money and stuff like that. When I talk to Ashley Merchant either today or tomorrow, I will let y'all know in an updated video if we can hire her. If not, we'll just put some money up and basically help out the family over there, because his kids ain't moving like he was. He got a son that's about to graduate high school. And unfortunately, fortunately, as a man to be a provider, Montunk actually was a provider. That's one of the blessings that was working with Young Thug, is we getting jobs, we operating in a space and in a place that 100% gives us legal jobs. We ain't got to be in the streets no more. I got to remember, all the stuff that they did was in the past. Moving on to the future and seeing bigger and brighter things. And I know it's going to sound like I'm making excuses and all that and everything like that. Not necessarily. I'm still going to say he was a dumbass when he took the stand and said the shit he said. It was stupid. Let's just be square. It was stupid. Some of the shit that he answered, he shouldn't have did it. But you too worried about perceptions and shit like that. Fuck everybody. I wouldn't care if I was on that stand. I wouldn't care what a Seti Nash or anybody got to say about me. I got a whole life to live. Y'all ain't gonna give a damn about this shit in 2 years anyways. So with that being said, I understand his mama was on her deathbed. It wasn't though he found out she was dying. No, she was on her way out of here. So he was trying to hurry the process up. And with that being said, as a man, I can say I get it. As a man, I could say I get it. If y'all understand, y'all understand. If y'all don't, then y'all don't. But share to keep your people aware. Subscribe, turn on the bell, stay notified. Check out this video at the end of
So
Whitaker.
we're going to strike everything
Yes,
he
that's
said
what I was,
today.
and
All right.
the notes, just like you did before, all the notes, they have to go back, give them to the court if you don't mind, put them under seal, or, and that's what I remember you doing, but whatever you did with them. And if they can't follow that instruction, please alert your honorable court if you don't mind.
You're right. Can we just ask that we could just stop our testimony and give them an opportunity to cross-examine him?
No, I guess you can ask, and the answer is no.
But I don't.
The answer is no. You can make a record.
Yes, Your Honor. Your Honor, I don't believe that he and my question was broad.
It's not your fault.
And I understand that, but Your Honor, the testimony that was given today, this was a one-time infraction, Your Honor. And we would just ask, we can understand that if his testimony, if the state no longer can question him, we would ask that all of his testimony from today is not stricken because of one mistake. Like, this was one mistake that he made, Your Honor. We would stop our questioning of him, allow the defense to cross him on what has come out now, but all of the information that he's provided this far, he has been careful. He has not said anything today that was even remotely close to what happened here right now. I believe it was a mistake on his part. Maybe as a state, I should have instructed clearer, and I will take that responsibility, Your Honor. But given that this was one moment in time, the state is going to ask that we will stop questioning. If that's the sanction that the state has to stop questioning him, Your Honor, we will take that sanction and ask that the defense be allowed to cross him, and that we be not allowed to direct him, and that's fine, but not that his entire testimony from today be struck, Your Honor, given that that was one mistake that he made very short in time, Your Honor.
All right,
We would just
understood.
ask that.
Do I need to
Ruling
respond to that,
stands.
Your Honor?
You don't
Okay.
need to.
Thank you.
Yes.
I did not mention it, but also all the exhibits admitted through this gentleman need to be taken back under seal
Yeah.
as well and disregarded by the jury, please.
Do you have another witness available?
Yes, Your Honor. We're
Okay.
trying to figure that out.
All right, go ahead and get them lined up.
Excuse me, Your Honor. I have one question. Is retired investigator Dennis going to return to the stand at some point? I'm not sure if the state had planned on that or not, or if your sanction would bar that as well.
Oh, no, he won't be returning.
Thank you, Your Honor. I just wanted that clarified.
Unless you'd like for me to have him come back and admonish him. But I'm not going to do it in front of the jury because I don't think we need to highlight it further. Okay. I kind of would like to tell him he should have known better, though. Y'all can just relay that. Okay.
Excuse me, Your Honor, and I'd like to renew my motion for mistrial prior to the next question.
All right. It is denied.
Thank you.
Okay. Do you have another witness you can put up now, or do I need to give y'all a few minutes? Okay.